Good morning. Welcome to Ag Law's Undercover Investigations and Exposing Animal Cruelty. For the next hour and a half, we will focus on Ag Laws, their history, and their constitutional issues. Briefly, Ag Laws criminalize the taking of undercover videos on farms, assigning increased penalties to those who go against the agricultural industry. But I'll leave it to our speakers to go more in depth. And they are Kristen Strawbridge, the Illinois State Director for the Humane Society of the United States, an advocate for animal welfare legislation and an activist against Ag Laws. She played a crucial role in the passage of the law that banned the sale of shark fins in Illinois. Vandana Bala, the General Counsel for Mercy for Animals, a group whose undercover investigations have brought to light numerous offenses committed in the farming industry, including the first ever felony conviction for cruelty to factory farm poultry and charges of criminal animal abuse against two different factory farm owners. State Senator Mark Stoops, Indiana State Senator for District 40, when the Indiana legislature proposed an Ag bill, Senator Stoops took an active stance against it, saying, "This is an attack on our First Amendment rights and another example of big government protecting industry at the expense of public welfare." And finally, we have Dan Ashta, a Chicago area attorney who is currently pursuing his LLM in environmental and natural resources law from Lewis and Clark Law School. In addition to discussing Ag, he will talk about his fellow strikingly pro-agriculture law, the Animal Enterprise Terrorism Act. And we will begin with Kristen.
Thank you for having me here today. I'm an esteemed colleague. My esteemed colleagues on this panel. Just want to talk a little bit, give you an overview of Ag, and get started. So, the United States is a nation of animal lovers. How many of you have pets? There are anti-cruelty laws in all 50 states. Cockfighting is illegal in all 50 states. Dogfighting is illegal in all 50 states. What about farm animals? There was a study done by Oklahoma State University and the Farm Bureau that asked, do you agree with this statement? It is important to me that animals on farms are well cared for. 95% of people in that study believe that animals should be well cared for on the farm. There's a huge gap between what people want and what animals get in our society today. Currently, there's no federal law that protects animals while on the farm. Many state exemptions on the cruelty statutes, they all exempt farm animals or husbandry. There's virtually no protection for these animals at this time. This is what people think of when they think of animal agriculture. But sadly, this is what the case is at many of the factory farms. This is the picture of animal agriculture today, largely. HSUS has worked to expose many of these abuses on farms, such as bear and battery cages, veal grates, tail docking, where the tail is cut off without anesthesia, and gestation crates, where most of the breeding pigs in the U.S. spend their lives. They can't even turn around. There's no space for them to even turn around. This is what Big Ag wants you to see. Nothing. What we try to do is shine a light on these abuses, and we do that through investigations is one of the means. We've had quite a few big investigations over the years. In 2008, an investigation at California's Hallmark meat packing led to the recall of 143 million pounds of beef and a judgment of nearly $500 million against the slaughterhouse owners. Another investigation in 2009 showed shocking abuse of infant veal calves at Vermont's slaughter plant. And then in Wyoming, at a hog farm, there was a big investigation, and then these 5 people were convicted of cruelty. The industry's response to these investigations and uncovering this cruelty and these abuses has been ag-gag bills. There are several types of ag-gag bills. One type of bill bans taking a photo or video on the farm without permission. Another type makes it a crime for an investigator to gain employment at a factory farm. And most recently, there's bills that require mandatory reporting of animal abuse with impossibly short timelines, and they require the footage to be turned over to authorities, say within 48 hours, which ruins the undercover investigation really. And you can't really, in some places, rely on the authorities to do anything about it. There's 6 states that have some sort of ag-gag law on the books right now. In 2013, there are 11 states where bills were introduced. I'm going to talk about one of
Jackie
them.
McConnell, exposed in this undercover video for extreme cruelty to horses and sentenced for his crimes. But now Tennessee politicians have passed a bill to silence whistleblowers, covering up the abuse and protecting the next Jackie McConnell. The Tennessean says, don't be fooled. The Knoxville News Sentinel calls this a bill about protecting animal abusers that would facilitate animal cruelty. Call Governor Haslam, tell him to veto this bill and stop the animal cruelty cover-up.
So as you can see, after we did the investigation of one of the worst Tennessee walking horse abusers, he's just notorious. Tennessee passed, both houses passed an ag-gag bill. And so we launched a huge campaign, and with many partners, launched a big campaign to veto the bill. People were outraged. Even Carrie Underwood was upset about it. So this was huge media all over the country. And then New York Times front page, Sunday, there was an article talking about this as well. After that campaign, thousands of calls to the governor, thousands of people getting involved, Governor Haslam vetoed the bill. That bill required anyone reporting factory farm abuse to turn over the footage within 48 hours. The Attorney General in Tennessee said it was constitutionally suspect. As with all these bills, they are constitutionally suspect. So in 2013, animal advocates were victorious this year. Journalist Will Potter said that this was the best thing to happen to the animal protection movement that he can remember. Largely, it brought so many different groups together for one issue: environmental groups, civil liberties groups, journalists. It was, everybody was involved. I don't know how many people on our sign-on letter. So I don't know if it's necessarily a good thing, but it has put everybody together on one cause and built our network. Temple Grandin said that these bills were the stupidest thing that Big Ag ever did. Even the National Pork Producers Council did a study of the ag laws and found that 99% of the stories about it were negative. That's true. I haven't seen too many positive stories about it. And San Francisco Chronicle called ag bills the worst PR gaffe since NUCO. So what next? Companion animal abuse, is abhorred. And people are outraged when they see this type of abuse, companion animals, horses, dogs, cats. We have to keep up the fight to expose the abuses and make sure that abuses to farm animals are treated in the same regard. And this is just one pig in one crate for her entire life. What would you do to get your dog or cat or your pet out of a crate like this? So it's a call to action to get everyone involved. And then here's some contact information. Our Farm Animal Protection Public Policy Manager, he has great Twitter. We want to keep up on farm issues. Facebook, we have our Farm Animal Protection has a website, and then also I have an Illinois website if you're interested in what's going on HSUS-wise in Illinois. We do a little bit of everything. And then that's my email if anybody wants to contact me at any time. Okay, thanks.
No, I don't. Thank you. My name is Mark Stoops. I'm a state senator from Indiana. District 40, which is Bloomington, and then Monroe County is the area around it, which also includes, many of you may know, Indiana University. And I didn't bring a PowerPoint because I'm going to be talking about how this bill advanced through our state legislature, and basically you'd be looking at pictures of a bunch of white men in suits, myself included. And but I wanted, as you mentioned, there are 3 different types of ag-gag bills. Indiana tried to pass a bill that included all 3 versions in one. So there was the restriction on recording on an industrial farming operation. There was a restriction on falsifying your employment application and penalties associated with that. And then there was also the reporting requirement. So if we look at them one by one, Indiana, of course, has one of the highest number of confined feeding operations in the country. So we are, I think, 4th or 5th in the country in number of confined feeding operations. And many of the legislatures in Indiana, and again, keep in mind Indiana has a supermajority Republican Senate and House, and also a Republican governor, are very interested in protecting those operations. So in Indiana, the ag-gag bill was actually expanded to include not only industrial farms, but also all industry. So you can picture any business in the state is now protected against having people record illegal activities, is what it amounts to. It's like an open invitation. We can pass this bill, come to Indiana, and you can get away with whatever you want, because if somebody catches you, they're the one that's going to be liable. The criminal penalty for recording on a farm or other industrial operation is a misdemeanor. In Indiana, that's a $5,000 penalty and a year in jail maximum, so pretty steep. So as this bill is introduced by Senator Holdman in Indiana, who is well known for bringing many of the bills forward from the American Legislative Exchange Council. So ALEC, many of you know, you get a group of industries who provide the money and write the legislation. You have a group of legislators that come, they get briefed on that legislation, and they take it back to their states. So that's why you get many of the same bills being introduced in legislatures across the country, ag-gag included. Senator Holdman authors a bill. It proceeds through the Senate. There are a number of changes. In some of the language, like the reporting requirement of 48 hours. So if somebody, because concerns are brought up about the fact that these are people that are recording illegal activity, and we have whistleblower protections, then shouldn't they have the ability to get this information out to the public? So that was interpreted as, you must turn that video or picture over to an authority, meaning police or some type of regulatory agency, within 48 hours. My question was always, what happens after 48 hours? Was it still not an illegal activity? Did that activity suddenly become legal after 48 hours? And what does this regulatory agency or the sheriff's department or the local police do with this person who turns over this video after 48 hours? Because now they're a criminal. Now they're subject to the misdemeanor penalty. One of the problems that we've always found, and I'm sure many people have across the country, is that the regulatory agencies themselves, besides being understaffed, for instance, Indiana has Indiana Department of Environmental Management Management has 11 inspectors, 2,000 operations to investigate. And there's no way they can do it. But also, do they really, if they're given the information, do they really follow up and press charges? And the answer typically is no. And what about local law enforcement? You may have a large employer in your area. And remember, in Indiana, we're speaking not just about industrial farms, but also all industry. So say if information is turned over to local law enforcement, what are the chances that they're actually going to do something about it? What are the chances that the prosecutor, an elected official in that town, is going to file charges? So slim to none. And so these whistleblowers, these people that actually go in and get this recorded evidence, are putting themselves in really very difficult legal positions in these states with the ag laws. So this bill passed the Indiana Senate and then advanced to the House of Representatives. It was sponsored by another representative friend who has a 4,000 hog farm in Indiana. But something interesting happened in the House. It was actually decided after a few changes. There was an amendment to actually remove the recording language, and the employment, falsifying your employment application was actually beefed up slightly. But what happened before it advanced in the House is a group of House members actually decided that they were going to try to make it pass constitutional muster, that it was too much of an infringement on First Amendment rights, and even with the Republican supermajority, who's mainly concerned about the Second Amendment right to bear arms, there were enough people concerned about First Amendment rights, and they gutted the language so much that the Senate author, who must approve it in a conference committee in the session, refused to allow those changes. And so, luckily in Indiana, that bill was shelved. And I've been, as far as I understand, that they're still working on it. They're going to have another version to bring forward next year. A couple of other issues we had in the same vein. Another ALEC bill, American Legislative Exchange Council bill, that was brought forward was a constitutional amendment. So keep in mind, this is an amendment that has to pass the legislature twice in 2 different sessions. And this is an amendment to the right to hunt, fish, and farm. And the actual language on this is basically the Constitution provides that hunting and fishing and farming are the preferred means of managing and controlling wildlife. And this also, being a constitutional amendment, once it's in our Indiana Constitution, could very much affect local ordinances controlling factory farms, these confined feeding operations, because it has a greater level of protection, a greater level to meet in court. And many of the concerns, this actually is passed legislature once. It did not move forward last year. There were a number of concerns. For instance, Department of Natural Resources was concerned that bill would hinder their ability to legitimate wildlife management efforts. And some independent farmers who have had a lot of trouble with confined feeding operations that are next door to them. For instance, one set of family farmers had to move. Their farm was located in the country. They had to move and get an apartment because the smell was so bad. That spent years in court, and our local Hoosier Environmental Council was actually successful in getting that situation corrected. But it was a great deal of expense for these small family farmers trying to protect their operation from a neighboring confined feeding operation. So I just want to bring up a couple of points. One is obviously that these ag bills would be very difficult to prosecute, but they'd also be very difficult to defend against. Because the language is so vague, the fact that it is, I think on the face of it, blatantly unconstitutional. But in Indiana, this expansion of the language to include all businesses is troubling. You know, it's bad enough that they're trying to protect illegal activities, inhumane activities on factory farms, but when you talk about all industries, you're thinking about employment or safety regulations for employees, what employees are limited as far as reporting illegal activities by their employer. The unions were very concerned about the language. And one of the reasons that it actually did not pass the House, from what I understand, is that there were members that were concerned that might limit their ability to go in and film Planned Parenthood. So interestingly enough, it was something that affected their own ability to go after an organization they didn't like that woke them up to this bill. Yeah, it's interesting, and I always thought that was a strategy that we have to keep in mind on many of these bills, is we have to point out how this is going to affect what they want to do as well. And I just closing, one of the things I thought about as this bill was moving forward was the people that are actually going in, that are being hired, going in and filming this activity, have to be heroes. They have to be. Can you imagine going into a place where you are slaughtering animals 8 hours a day? And just the workers in general that do this, how do they do it? Is there some type of traumatic stress there? Are these individuals that just become kind of deadened to the fact of what they're doing, and that these are animals that are feeling pain? And I mean, many of us know hunters. I know hunters who talk about they see a deer and they just, oh, it's right there, and it just went pop, and it died. Or is it like a Dick Cheney, you can go out and shoot 70, 80 birds in an afternoon and feel good about it? So I think another level of legislation is, what are these workers asked to do to earn their wage, and how is it affecting them? How many of them have mental disorders similar to somebody that's gone off to war? So anyway, I thank you for inviting me up today, and I'd be happy to answer any questions.
Sorry, everyone, we're having a little computer problem here. I just did. Oh, here we go.
Again, we apologize. And now, Vandana Bala.
Sorry for the delay, everybody. So my name is Vandana Bala. I'm the General Counsel for Mercy for Animals, a national nonprofit farmed animal protection organization dedicated to preventing cruelty to farmed animals and promoting compassionate food choices and policies. So by now you've already heard about the history of ag bills, what the current climate is in terms of the bills that are out there, some of the different types of language that are included on these bills, and sort of a detailed analysis of what happened in Indiana last year. So I'm going to focus my remarks on the undercover investigations portion of this panel to really sort of focus on the practicalities of what these ag bills are all about. What are they really after? And what they're after is keeping consumers in the dark about where their food comes from by stifling and hopefully eliminating altogether from the industry standpoint undercover investigations. Now I do apologize, there's going to be a bit of overlap between what I'm going to be talking about now and some of the other speakers today, but hopefully that'll just make these points really hit home. As was already mentioned, there really aren't any federal laws that protect farmed animals during their lives on factory farms. The Humane Methods of Slaughter Act, as the name suggests, applies only at the time of slaughter. State laws do exist, animal cruelty laws. Those are primarily geared towards protections of companion animals, dogs and cats. The vast majority of states exclude farmed animals from the scope of animal legal protections. And what they exclude specifically are common farming practices or customary industry practices, which are really some of the worst, most gruesome types of cruelty that can be inflicted upon these animals. And yet they are legal at this point. And I'll give you some examples of what some of these practices are. Extreme confinement, cramming animals in cages so small they can't walk, stretch their limbs, or even turn around for nearly their entire lives. Tail docking, basically ripping off the tails of animals without any painkillers. Castrations, ripping out the testicles of baby piglets by untrained people with no anesthesia at all. You'll see, a form of euthanasia of piglets is to slam them headfirst onto the ground or onto a hard surface. It's known as blunt force trauma. It's very horrifying, it's very gruesome. And all of these practices are currently legal. Modern agricultural practices they really shock and horrify most Americans. They raise also a host of food safety concerns, environmental concerns, labor and workplace safety concerns, and employees who work in these facilities, as the Senator alluded to, they're in this culture of cruelty where they have to do some really horrifying work all day, every day. They end up, it's very easy to take that even further and engage in malicious abuse, torture of animals. We see that a lot because of this really cruel culture that they're in. And so all of these practices are simply out of step with most Americans' values, especially right now when consumers are paying more attention to what they're eating. They're demanding greater transparency in food production. And this is completely at odds with what AGAG is trying to do. And since the industry is shrouded in secrecy, undercover investigations play a really crucial role in educating the public and in trying to bring some oversight and some accountability into a pretty broken food system at this point. So I'm going to be talking about briefly how we do investigations, why we do investigations, some of the results that we've obtained as a movement from undercover investigations, and why that is so upsetting to the agricultural industry that is prompting them to fight back with these ag-gag bills. Modern industrial agriculture is concentrated in the hands of a relatively small number of industrial giants. So the days of small farms with red barns and white picket fences are, for the most part, gone. Instead, consolidation and mass production are the norm, and it's mainly to maximize agricultural profits. Every year, okay, so now this graphic is not going to work. It's a simulated slaughterhouse line that shows the rates of slaughter per second of chickens, pigs, and cows. Unfortunately, it's not coming through here. It's helpful to show the enormity. I don't think people can really grasp, over 8 billion land animals every year. Truly, how many animals that is. 99 out of every 100 animals in this country are farmed animals. So it's not hard to imagine that with that level of mass slaughter going on, the ways in which these animals are treated is truly horrifying. So that brings me to the question of why do we do undercover investigations? We do so primarily to educate the public. Undercover investigations shine a spotlight on the abuse and cruelty that is inflicted upon the billions of animals each year who are consumed for food. Consumers have a right to know this information, and they want to know this information so that they can make informed choices. Mercy for Animals has a history of over 20 undercover investigations into factory farms and slaughterhouses around the country. And every time we conduct an investigation, what we see is truly, truly horrifying. We've done investigations into veal farms, into slaughterhouses, dairy farms, hog farms, hatcheries, and livestock auctions. We've conducted investigations in numerous states across the country, including Ohio, Maine, North Carolina, Colorado, Minnesota, Texas, and California. So this is a map. I think you've already seen this before today. This is a map showing the different groups that do undercover investigations and where those investigations have taken place. And in the vast majority of these states, ag-gag bills have been introduced. Now, our undercover investigations are employment-based, which means that the undercover investigators get hired at these facilities as employees. And they go to work every day at these facilities just like any other employee. The only difference is that they have hidden cameras so that they can document the abuse and the cruelty that they see. This is incredibly hard work. I can't even begin to imagine what these brave individuals, how they do it. They witness on a daily basis horrifying cruelty and violence. It's incredibly physically and mentally demanding. And yet these individuals do so, and they continue to do so, because undercover investigations are truly one of the most effective tools for animal advocacy. Video footage documenting horrific acts of intentional animal cruelty, as well as the standard industry practices that we've been talking about today. They have led to significant improvements in animal welfare, and they continue to pave the way for even greater advances. So I'm going to talk a little bit about how we use our undercover investigations. Undercover investigations are used and can be used to effectively enforce the very few laws that do exist that protect farmed animals. We've already talked about the absence of real state or federal protection, but in terms of the state animal cruelty laws, the only acts that that can be the basis of a prosecution are extreme acts of intentional violence and torture that are inflicted upon these animals. So Mercy for Animals conducted an undercover investigation in North Carolina of a Butterball turkey factory farm. After that investigation, we took the footage to the district attorney of that county. A 2-day raid of that facility was then conducted by the sheriff's department. And after that, charges were brought against 5 Butterball employees for criminal animal cruelty. All 5 were convicted, and that includes the first ever felony conviction for cruelty to factory farmed poultry. And in addition, in this case, a top-level North Carolina Department of Agriculture official was convicted of obstruction of justice for tipping off Butterball about the raid. Similarly, Mercy for Animals conducted an undercover investigation into a facility in Castro County, Texas, that housed calves until they were old enough to be sent to dairy facilities. During this investigation, we documented some of the most gruesome acts of cruelty that I've ever seen, including workers bludgeoning calves in the head to death with pickaxes. Once again, the undercover footage was so compelling that the DA really had no choice but to bring criminal charges. And he did so against the owner of the facility and 6 employees. The owner was subsequently convicted of animal cruelty, and that was a huge victory because this investigation took place in the heart of cattle country in Texas, where this sort of abuse and these sorts of practices are more often than not the way of life. So the significance of these convictions is that they bring issues of farmed animal cruelty into the public sphere. People aren't really aware of where their food comes from. There's a huge disconnect going on in this country. They're not really aware of where their food comes from or how animals are treated before they reach our plates. And so by raising awareness of these issues, we do succeed in changing the way that people look at farmed animals. And we provide them with the information that they need to make informed food choices. Investigations have helped to pass new laws for improved treatment of farmed animals. We heard about Prop 2 in some detail today, so I won't really go over those details, but I will say that just 4 weeks before Prop 2 was up for vote, Mercy for Animals released an undercover investigation of Norco Ranch, which is the state's largest egg producer. That undercover investigation showed birds packed into cages so tightly they couldn't even spread their wings, live birds neglected and suffering lying on top of stacks of dead birds, and hens injured and trapped by their cages. The public was outraged by the video footage and the conditions that these animals lived in. It was part of an effort to make Prop 2 pass with overwhelming support, making California the first state in the nation to ban battery cages. Undercover investigations are also incredibly helpful to pave the way for better corporate animal welfare policies. I'll talk a little bit about a recent investigation that Mercy for Animals did, this time into Betancourt Dairies, the largest dairy facility in Idaho. And it's a supplier of milk that's used for cheese that goes to Kraft, Burger King, and Wendy's, to name a few. In this investigation, workers were caught dragging a downed cow, a cow who was unable to walk, dragging her by her neck with a chain attached to a tractor, kicking, stomping on, and beating cows, violently twisting their tails in order to deliberately inflict pain on these helpless animals. One worker was convicted of animal cruelty in January of this year. But in addition to that criminal conviction, we got a corporate victory in this case, and that was the investigation prompted Kraft Foods to announce a new policy requiring all of its suppliers to phase out the cruel practice of tail docking of dairy cattle, which is basically, there's different ways that some of these facilities tail dock, but essentially they cut the tails off dairy cows without any anesthesia or painkillers at all. And that policy change was announced immediately at the time of the release this investigation. Mercy for Animals' investigation into a gestation crate facility that supplied pork to Costco prompted Costco to implement a policy requiring its suppliers to phase out the use of gestation crates, which, as we've heard already, are filthy metal cages that are so small pigs can't walk, lie down comfortably, or even turn around. And in fact, following numerous undercover investigations by a number of different groups and the public outrage that resulted from that, over 50 major retailers, grocers, and suppliers have all publicly announced that they are going to phase out the use of gestation crates. Most importantly, undercover investigations are truly the most effective way to educate the public about the grim truth behind factory farming. And they're the most compelling way, I think, to encourage people to adopt a plant-based diet. What I have here in this slide is just people's reaction to watching our undercover footage. I mean, people really have no idea this is what's going on. And when they see, the sad reality of the situation, I mean, they're devastated, as you can see. Investigations play an important role in other really vital areas as well. These investigators, who are whistleblowers, expose not only animal abuse, food safety issues, unsafe working conditions, violations of labor laws, violations of environmental laws that may be going on at these facilities. In fact, the largest beef recall, as Kristen mentioned, in United States history, and this is beef that was supplied to the National School Lunch Program, was the result of an undercover investigation by the Humane Society of the United States. So undercover investigations have had a very, very positive impact when we think about animal welfare, food safety, environmental issues, labor issues. But obviously there's one industry that's negatively impacted by investigations, and that is the agricultural industry. There was a study that was done by Kansas State University that documented that, as a whole, I'll read the quote here, media attention to animal welfare has significant negative effects on U.S. meat demand. And that's the problem for the industry. Every time an undercover investigation is released, demand for meat, eggs, and dairy products declines. And so I have a graph here that shows, over the years, demand for these products is increasing. And then right around 2005, various groups started doing more investigations and releasing these investigations, and demand dropped significantly. And undercover investigations have resulted not only in a decline in the consumption of animal products, but also in a lot of negative publicity for the industry, and corporations who purchase from these facilities end up dropping them as suppliers. So they're losing a lot of money because of our investigations. So let's see, I do have a video that I want to show. Yesterday, Mercy for Animals released a new undercover investigation. So this is sort of hot off the presses. One second. Just give a little background. So we released a new undercover investigation into a hog farm in Minnesota. And this investigation shows primarily standard industry practices. There is some, intentional and malicious cruelty by the employees, but we have, pregnant pigs confined in tiny gestation crates, so small they can't move for nearly their entire lives. Workers slamming fully conscious piglets headfirst into the ground and attempt to euthanize them. Workers, ripping out the testicles and cutting off the tails of piglets. And sick and injured pigs just left to suffer without any veterinary care. So we're trying with this investigation to encourage Walmart, the country's largest grocer, to implement a ban on the use of gestation crates by its pork suppliers, similar to all of its, all of these other companies that have done so, including, the majority of Walmart's competitors. So far, Walmart has refused to adopt even this most basic policy. So I would like to play the footage for you. It is, caution you, it is very disturbing. But this is what happens in these modern industrial farms. This is not anything particularly unusual, and this is exactly what the industry, the agricultural industry, is fighting so hard against. What I'm about to show you is an undercover investigation and what ag-gag bills are designed to prohibit.
Walmart likes to tout its low prices, but when it comes to the pork sold in its stores, animals are left to pay the highest price of all, a life filled with misery and deprivation. New hidden camera footage recorded by a Mercy for Animals investigator at a Walmart pork supplier reveals pregnant pigs confined to tiny fly-infested cages so small they are unable to even turn around or lie down comfortably for nearly their entire lives. Workers mutilating piglets by cutting off their tails and ripping out their testicles. And piglets being violently slammed against the ground. Although this kind of cruelty is shocking, it is considered standard practice at Walmart pork suppliers nationwide. Pigs are punched, slapped, and screamed at as workers move them. Workers lift baby piglets over their heads and violently slam them against the floor in a crude attempt to kill them. Piglets are often thrown with no regard to their welfare. Workers routinely carry up to 8 piglets at a time. This carelessness often results in piglets being dropped on their heads. Dull clippers are used to cut off tails. Testicles are ripped out of screaming piglets. Painkillers are never used. Dead and dying piglets are a frequent sight at this Walmart pork supplier. Many baby piglets are crushed to death when they get caught between their mothers and the narrow bars of their cages. Locked in tiny cages called gestation crates, these pregnant pigs can only watch and wait as life goes by. Managers acknowledge the toll such crates take on the pigs. These curious and social animals are driven mad by boredom and stress in these nightmarish conditions. This is torture, plain and simple. Gestation crates are so inhumane they have been outlawed in the entire European Union and 9 US states. Responding to customers' concerns, McDonald's, Kroger, Costco, Safeway, and nearly every other major food provider in the country has committed to eliminating gestation crates, but not Walmart. Walmart continues to condone this blatant animal abuse. As compassionate people, we cannot allow this to continue. Please join me in calling on Walmart to take a stand against animal cruelty by ditching pork from suppliers who confine pigs in gestation crates. And you too can help stop animal abuse by leaving pork off your plate and adopting a vegetarian diet. To take action, please visit walmartcruelty.com.
So, undercover investigations end up costing these industry groups a lot of money. And that is why the industry is going to such desperate lengths to fight these investigations. They don't want the public to see what I've just shown you because it's horrifying. But rather than change these cruel practices, the industry is now using its massive wealth and influence to try and enact laws that would criminalize undercover investigations. And the goal is to keep consumers in the dark about what goes on behind the closed doors of America's factory farms. Thank you.
And now Dan Ashton.
Hi, my name is Dan Ashta. I'm going to be talking about the Animal Enterprise Terrorism Act. It's codified at 18 U.S.C. Section 43. Is the audience familiar with the statutes? Could I ask for, nobody really knows the statute. Well, Vandana spoke a minute ago about legislatures enacting laws that would criminalize undercover investigations. The Animal Enterprise does that. Animal Enterprise Terrorism Act, AETA, does do that. It criminalizes other things in addition to undercover investigations. The statute's at 18 U.S.C. 43. There have been earlier versions of the statute called the Animal Enterprise Protection Act, or AEPA. There's AEPA of 1992. There's a 2002 amendment. And then the Animal Enterprise Terrorism Act replaced AEPA in 2006 at that statutes at large number. I do talk mostly about AETA. I've provided a statute. There's a supplement in your handouts of the statute. It's an 8-page. I provided an 8-page handout of statutes. The first 4 pages are AETA. Pages 5 and 6 are AEPA of 1992, and pages 7 and 8 of that handout are the 2002 amendment. I don't want to distract you and ask you to read a statute while I'm talking, but experience has shown me when I've presented this before, it's a very unique statute. It uses a lot of unique language and has a unique structure. So I've had audiences tell me that having the statute in their hand while I'm presenting is helpful to them. So I've provided it for you. The first 4 pages are AETA. I talk mostly about AETA, but AEPA is still relevant because, well, my work, I assess the constitutionality of AETA. And assessing the constitutionality of a law involves construing it properly. And construing AETA properly involves comparing it with earlier versions to glean congressional intent. So, I can't review all the changes in the statutes, but a review of the changes that have occurred at that section is helpful to an understanding of the present language. AETA chills speech. It's a federal criminal law. It uses the term terrorism, and it chills speech on a number of activities that involve animal enterprises, including agricultural concerns, operations that use animals as food. It does other things. That's one of the things it does. AETA contains 5 paragraphs, A through E. A is its prohibitions subsection. Paragraph B provides penalties. Paragraph C is a restitution provision. D is definitions. The statute provides definitions for some terms, but not others. Paragraph E contains some exemptions clauses, which some people call savings clauses. In paragraph A, AETA actually prohibits multiple things. If one looks at the statute, there's subparagraphs in paragraph A, and the subparagraphs are separated by the word or. The A1 and 2A offense, which I'll call 2A, prohibits causing damage or property loss. The A1 and 2B prohibition, which I'll call 2B, prohibits causing reasonable fear of serious bodily injury by a number of acts. The 2C provision is attempt or conspiracy. No provision in AETA operates unless a person uses interstate commerce, which could include cell phone use, internet use, use of mail. Somebody uses interstate commerce for, quote, for the purpose of damaging or interfering with the operations of an animal enterprise, close quote. Now, as I said, these are disjunctive offenses. So somebody could violate, say, 2B by causing someone to be afraid, regardless of whether or not damage or property loss occurs. Similarly, with the 2A offense, somebody could be convicted under this statute by causing damage or property loss, regardless of whether any fear occurs, regardless of whether any bodily injury occurs, or is even attempted. Similarly, in paragraph B, which provides penalties, there's 2 tracks of penalties. Some of them deal with bodily injury, but others deal with economic damage. And somebody could be punished under this statute for causing damage or property loss where no damages occur except for economic damages. In fact, the statute provides up to 1 year imprisonment When no economic damage occurs, no fear occurs, no bodily injury occurs. Paragraph D defines some terms but not others. One key to the arguments I present is that animal enterprise is defined, but it isn't defined. It's defined as an enterprise that uses animals, or uses or sells animals or animal parts. Well, what is an animal? I took animal law class, our textbook, chapter 1, titled, What is an Animal? And this is an animal law symposium. You look at the different animal cruelty law statutes in the different states, and you're going to have different definitions of the term animal. Similarly, in the federal landscape, you have different definitions of the term animal. Endangered Species Act is going to contemplate the term more broadly, and Animal Welfare Act, as you probably all know, has a lot of exceptions. I don't think it covers insects. I don't think it covers birds and fish. And that is important for reasons we're going to get to. Some constitutional problems off the bat is that it covers speech content. So there's First Amendment issues. We've got to strictly scrutinize it. Even if the now there is an exemptions clause that purports to exempt First Amendment activity. So even assuming for the sake of discussion that the statute doesn't cover speech, you'd still have constitutional issues in terms of Fifth Amendment, arbitrary or discriminatory enforcement due to all the undefined terms. When you have speech at play, as I think we do here, those concerns as to precision and the duties of the Congress, of the legislature, to handicap non-legislative branches from legislating, those demands of precision increase as you have in a commercial regulation. There's more leeway, but when you're talking about fundamental freedoms, it doesn't have to be speech. It could be voting, it could be movement, it could be association. Here we have speech, and those demands increase. So what we have is First and/or Fifth Amendment combining. And we have a statute that has clear terms. Damage is a clear term. It's broad, but it's pretty clear. Property is a clear term. It's still broad. And within that, you have terms that don't really have any meaning, like animal enterprise. So the statute casts a wide net, and within that net, non-legislative branches the statute essentially requires the executive branch and the judicial branch to legislate, to supply meaning for terms that go undefined by the statute. Agriculture. The court has said, Supreme Court has said that speech on matters of public concern merits special protection. And agriculture raises a number of issues of public concern, as we've been discussing. I am going to jump to my conclusions because we have limited time here. I'm going to state my conclusions and then try to explain them. AETA cannot be enforced in all its applications. The number of applications that involve damaging or interfering with and causing damage or loss of property to any enterprise in our society that uses or sells animals or animal parts is virtually limitless. There's almost no commercial enterprise that does not use animal parts. A number of authors have written about this. Even if you were to try to have a strict vegan lifestyle, it's extremely difficult, if not impossible. An example of a writer would be Professor Wise. He writes that slaughtered cow, the parts, things like the fats, bloods, they're used in inks, in fuels, in plastics. So take, for example, you go to a vegan restaurant and you don't eat anything made from an animal, but what if you get a bill and, well, you will get a bill, and what if the ink has an animal part in it? What if the ink is made partly from the blood of an animal? So technically, the statute is very broad. I mean, would that operation or that enterprise, the vegan restaurant, be using an animal part for profit? If you look at the definition of animal enterprise in paragraph D of the statute, it's any enterprise that uses or sells animals or animal parts for essentially any purpose, including profit. So then that is very wide of its possible applications. Is anyone here familiar with United States v. Stevens, the Crush video case? Yeah, the Supreme Court expressed concern there that statute criminalized depictions of animal cruelty. And the executive branch said, well, we're going to limit it to extreme cruelty. This isn't going to be a problem. It's not going to cover videos on slaughterhouses or anything like that, because the only purpose of this bill is crush videos. When it was first passed, the executive branch said this. We're only going to use it to go after crush videos. And there won't be any problems. And then the executive branch started using it for dogfighting. And then the statute was facially challenged. And the court said, the judicial branch is not permitted. The Constitution doesn't permit us to rely on these representations of the executive branch. It doesn't allow us to rely on good intentions. If the statute can be abused, it's an unacceptable constitutional problem. What if the executive branch changes its enforcement policy, as it did from crush videos to dogfighting? What if another administration comes, 20, 30 years down the line with different policies? So Congress, when we have speech at play, there's demands of precision, not only for today, but for the future. ADA is so standardless that if non-legislative branches don't use it in a discriminatory fashion, it will nevertheless be arbitrary. Because of its almost limitless applications, the executive branch has to decide. Prosecutorial discretion, as United States v. Stevens, the opinion talks about, prosecutorial discretion, when you're talking about fundamental freedoms, is not a virtue. It's a constitutional flaw. So here, the statute not only invites, but requires prosecutorial discretion, and that is what provides a guarantee that the statute, if it is not enforced discriminatorily, will be enforced arbitrarily. And its potential for content discrimination is unconstitutional. My remedies, well, it's unconstitutional as is, and non-legislative branches cannot add terms, as the Stevens opinion discusses. The executive branch in Stevens said, well, we'll limit the statute to extreme cruelty. The court said, well, the statute doesn't say extreme. We can't add, you can't add the word extreme, we can't add the word extreme, only Congress can add it. So that is the position of the Supreme Court today, and adding terms is a no. Severance would result in a meaningless statute that Congress never intended. If you severed everything from the statute that was unconstitutional, you have nothing left. So therefore, the legislature has to repeal it, or invalidation is necessary. We have legitimate alternatives. The statute does cover some crimes that we need to address. It's overbroad, but as far as the legitimate interests go, we have alternatives that are more constitutional, less speech restrictive. I say it's content-based. Paragraph A1 and 2A prohibition that covers damage or property loss, can punish speech and speech alone. Can you do something that causes property loss by not speaking? Yes, you can. But you can also violate the statute by speaking and speaking alone, and that is what triggers strict scrutiny. And 2B expressly mentions harassment, intimidation, and threats. So you can violate this statute by doing nothing but speaking. An undercover investigation might, cause somebody to bring this statute on. So we've got to strictly scrutinize it for its potential to unconstitutionally suppress speech on content basis. Content basis can be subject matter, it could be viewpoint, it could be speaker identity, especially when we're talking about controversial stuff, matters of public concern, even laws that potentially indirectly suppress speech are strictly scrutinized. An example might be, in case I'm thinking of Arkansas Writers Project, it taxed different magazines differently, or taxed magazines different. There was a few cases in the late 80s that taxed magazines differently than newspapers, or taxed different magazines differently, and the legislature, the state legislature came in and said, well, we're not trying to discriminate. You know, we have good reasons, sensible reasons for doing this. And the court said, well, it doesn't matter. It doesn't, legislative motive doesn't matter. This has the potential to discriminate on subject matter, speaker identity, those kinds of impermissible bases. So the Supreme Court would strictly scrutinize that. The big question is, can the statute cover speech alone, based on the content of speech? And this speech can. We strictly scrutinize, the courts strictly scrutinize different kinds of statutes, sometimes statutes that cover prescribable and protected speech. The big question is, or prescribable speech alone. The court has strictly scrutinized cross-burning legislation at times, because because cross-burning is speech, the court has held, whether it's prescribable or protected, you're doing nothing but speaking, and that's why the court strictly scrutinizes it for its potential to discriminate on the basis of viewpoint or subject matter, speaker identity. Arbitrary or discriminatory operation. I've seen in the cases 3 different kinds of laws, and they really, all 3 have the same effect. Laws that expressly discriminate on their face. No picketing except for labor picketing. Laws that make discrimination likely. Flag contempt statute. These are the respectful ways to treat a flag. These are the contemptuous ways. I also think, since this is an animal law event, I never know how to pronounce, I don't want to butcher the name of the church, but versus City of Hialeah, it's the animal sacrifice case. Similar thing, makes discrimination likely, the court held. Animal sacrifice, you know, as opposed to these other methods of disposal, make, you know, discrimination likely if not inevitable. Same thing with a law that lacks guidelines. I think you have elements of all 3 of these categories in AITA, but the result is the same. Even if, you know, a standardless law guarantees discrimination or arbitrary application because there are no standards. So it's going to be one or the other. And in these kinds of cases, severity of penalties is a factor in whether speech is chilled. You'll find that explicitly in the cases. And AITA's a terrorism statute with severe penalties. So if it's a misdemeanor versus a terrorism federal crime, that's going to affect the speaker's decision whether to take a chance. So it is a factor. I use, for construing statutes, I think I use the normal means, the express definitions in the statutes, the structure as a whole, comparative analysis, and common law dictionary. Same methods the courts use, the strict interpretists use. And then if you want to expand, some judges and justices like to look at legislative commentary, and some hate it. But if you want to look at the legislative commentary, if anyone wants to look at the legislative commentary, it's there, as I'm sure the panelists touched on. If you look at the congressional record, you'll find statements that show concern as to viewpoint discrimination, going after animal rights activists, those kinds of things. Enforcement patterns. If you're talking about a statute with the potential to operate on a content basis, you don't need to show actual abuses in terms of enforcement patterns. It could be an example would be Stevens. The court never ruled whether the speech was prescribable or protected or what. It was the potential to operate in all these ways that resulted in the court deciding that the statute was unconstitutional. But if you have an enforcement pattern that raises concerns, it's obviously going to demonstrate this, an actual case is going to demonstrate the potential. Same thing, if you look at the cases that have involved AITA, the government does use it selectively. And as the statute allows them, the Constitution doesn't allow the statute to do that, but again, the statute requires the executive to engage in selection among the applications, and it's chosen to go after animal rights activists, whether their activity is criminal or not. They're going after activists for their speech. There's a difference in legislative intent and legislative motive, as you probably all know. We could limit the statute if the language allowed it, and if limiting the statute would alleviate the chill on speech. The court discussed that in Citizens United, which was a involved a complicated statute with disputed parts. So the court in Citizens United discouraged lower courts from partial limiting constructions that would, that wouldn't alleviate a chill. We can't add terms, I think I mentioned that. And there's terms in AIDA such as damage and property that just can't be limited. They're not ambiguous. The word is the word. As I mentioned, there's two principal offenses here. I'll get into, I'm actually going to get into the word purpose and the phrase animal enterprise a little more. The express definition doesn't expressly define damage, but it does expressly define economic damage in paragraph D. And economic damage includes loss of profits. So loss of profits is part of economic damage. And according to the common definition of damage, economic damage is part of damage. So it includes a lot of things. Damage includes a lot of things, including economic damage, including loss of profits. Savings clauses I want to get to in a minute. It exempts some lawful economic disruptions. And I'm glad my previous panels prefaced this. I mean, are undercover investigations lawful? I think it's a matter of dispute. I'm sure the employer would say it's not. So that's a problem, as I'll get to. It's for Congress to define what's lawful and what's not. By saying we're going to exempt lawful economic disruptions, it delegates the legislative authority to other branches. So we have separation of powers concerns here. Surrounding terms. Stevens said, opinion Stevens, if the term is unambiguous, you can't use surrounding terms to limit it. That was an argument raised and addressed in Stevens. Even if we didn't have that, some defenders of the statute have said the words animals or records in the statute limit the definition of property. But if you look up property in Black's dictionary, it's not ambiguous. It includes intangibles as well as tangibles, as does damages. Actual enforcement in a case, the government has argued that damage isn't ambiguous. It's not vague. Look it up in the dictionary. Damage means damage. It includes reputational damage. So the government has argued that these terms include intangibles. The animals or records term doesn't apply to the second half of the clause. So the statute protects not only animal enterprises, but those associated with it, and it could be any property of the associates, lost profits, goodwill, those kinds of things. I said a comparative analysis is relevant. I can't nitpick right here now, but if you compare the two versions of the statute yourself, it's difficult to limit the previous or the present statute when the previous versions broaden. The progress has been to broaden this legislation. Congress removed the term stealing. It removed the term physical. It broadened the definition of animal enterprise. So I think that makes it more difficult for a court to limit the statute when Congress has broadened the legislation. Black's Law Dictionary, Webster's Dictionary. You can look for yourself as far as the definition of these terms. They relatively clearly include intangibles. And the court has said that there's a general presumption that the common law meaning plays. This was Scheidler, a case interpreting the term, among other things, property. To be, punish a speech directly, threats, intimidation, harassment. There's a few requirements that the cases require. The most important thing is specific criminal intent language, because the criminal intent requiring the government to not only prove it, but allege it, guarantees against viewpoint discrimination. Virginia v. Black, it's a cross-burning case. The court said, well, you could prescribe cross-burning with the intent to intimidate, but you gotta make sure that the intent to intimidate is alleged and proven. Unless there are guarantees of that, we don't know that the statute's not going to operate because of a person's viewpoint. That's what distinguishes between prescribable and protected speech, that criminal intent, intent to intimidate, intent to threaten. And AIDA doesn't specifically require it. Can we read it in? There's so many other I don't even know. Given it's a 2006 statute, it came after Virginia Black. There's other statutes that have the proper intent language that Congress is familiar with. So limiting the statute is not that easy, and there's so many other problematic aspects of the statute. AIDA deviates from the norm as far as modern speech crime statutes. Purpose raises constitutional concerns. It requires subjectivity. I think of a couple lines of cases. One is the loitering statutes that invalidated Morales v. Chicago is one. It's a 1999 case. Loitering with no apparent purpose, and the police officers would have to decide, does this person have a purpose? What's its purpose? It's different with intent. When we have a statute, and we do have alternatives, with the intent to intimidate, harass, because police officers, judges, our lawyers are more familiar with that type of language, with that type of nomenclature. When you're talking about no apparent purpose, it's a lot to put on a police officer. You know what? It's burdensome for the executive government officials as well as private citizens. So that's one example, and another would be a statute. I think there was a similar language in the Stevens statute, but also there's a case with Reagan v. Time that it had a statute, no reproductions of U.S. currency whatsoever, except those for the purpose for artistic, educational, scientific type purposes. Well, who decides what's an artistic purpose? What's an educational purpose? The Secret Service. That's again, it's a problem because different agents are going to interpret it differently, and there's no standard. It comes down to the subjective discretion of government officers. What's an animal? What's an enterprise? What's an animal enterprise? What is an animal part? Are we talking fish? Are we talking shrimp? Genes, insects, bees, transgenics, birds, fuels, gels, inks, plastic. There's no settled meaning for animal. I think of since World Series time, I hear the word damage all the time when you watch a World Series game. Big Papi, David Ortiz, he does damage. You throw him a changeup, you elevate a changeup, and he's going to do damage. Baseball teams use leather batting gloves, and so if you do damage against another baseball team and it causes that baseball team to lose profits, are you going to be prosecuted under AIDA? I highly doubt it. But the language of I'm trying to illustrate how wide a net that the statute casts. And technically, you could bring that prosecution under the letter of the law. So I'm just trying to illustrate that there are all these technical applications that would never come up. But, all these applications that would never come up. And so the non-legislative branches exercise their discretion and choose what they think is an animal enterprise, what's for the purpose of damaging or entering. So there's really no standard at all, if I haven't made that clear. Lastly, I want to address the savings clauses. There's a clause in AIDA that says nothing in AIDA shall be construed to prohibit expressive conduct, including peaceful picketing or demonstrations protected from legal prohibition by the First Amendment. And compare that with something Professor Tribe wrote, which would be crime to say anything in public unless the speech is protected by the First and 14th Amendments. That's really no standard at all. And it goes back to what the court has always said about casting a wide net and allowing non-legislative officers to legislate. This language has been quoted quite a few times by the Supreme Court. In Morales, in Reno are two more recent cases. I think Papa Christou v. Jacksonville, which was a loitering statute. I saw this statute in my animal law book. It was a New Mexico case, it was a cockfighting case, and the defendant said this term does not define animal, a rooster is not an animal, and the court agreed, and it cited this language. It said that the state legislature had to define animal, because it can mean a lot of different things to a lot of different people, and there is no settled definition. These are other things that Congress has said about savings clauses. One thing I haven't mentioned is that they shift the burden. Content-based statutes are presumptively unconstitutional, and these statutes recognize speech coverage. If there, constitutional statutes don't need savings clauses. If there wasn't a problem, why would the statute have that clause in there? They don't save, they increase the statute's potential for arbitrary and discrimination, arbitrary or discriminatory application. They don't decrease, they don't save the statute from that. They make it worse. There's something in E2 also. It says that nothing in this statute shall prevent an individual from recovering a remedy for suppressed speech. Well, that is inconsistent with First Amendment policy, that the First Amendment protects everyone. It protects speech generally. It protects the public who wants to know about these, the only way we know about these, we should know about these things, we should be talking about these things, and the only way we know about it is if we get the information to make the choices. And so speech suppressed, an individual speaker suppressed, even for a limited time, creates a public injury. We all suffer without the speech, we'd be making food choices without understanding all the costs and benefits at play. Let's see. Okay. Well, the statute's over-inclusive and under-inclusive. I said it's this is strict scrutiny. You're familiar with the test. I've talked about how it's over-inclusive. Under-inclusive. Yeah, there's plenty of really dangerous crimes that the statute doesn't cover. And it's not necessary because we have alternatives that are less problematic. Why doesn't the statute cover violent crime for the purpose of promoting or furthering an animal enterprise? Under strict scrutiny, this is generally a question that the government must answer. Also, if I was a prosecutor and I had to allege and prove the animal, the purpose element, I mean, it'd be easier to prosecute, if it's a serious crime, it'd be easier to prosecute a case without having to allege and prove that element. So I think it's problematic for a number of parties, including the public. And we have better alternatives. One example is 13 U.S.C. 1365, which covers product tampering, fraud, threats in connection with the product. We have 18 U.S.C. 844, which criminalizes bombing and arson, regardless of whether the person does so for the purpose of damaging or interfering with an animal enterprise. 18 U.S.C. 2261 is a speech crime. It's a cyber-stalking statute. So we have plenty of alternatives that don't require this problematic purpose of damaging or interfering with an animal enterprise element. I think you know my conclusions. And I am pursuing an LLM, but I'm not representing my school. So if you have a question, email me personally. Thank you all.
Do we have time for like a few minutes for questions?
Just a couple of questions.
Okay, does anyone have any questions for any of our panelists? You.
I'm just wondering if the panel could speak to, I guess we haven't heard a lot about food disparagement laws on a state-by-state basis since the Oprah Cattleman case. Can you maybe speak to the current state of state food disparagement laws?
Well, I can just mention mine. I mean, I'm obviously focused with one law. Yeah, I mean, I like to make the argument, even assuming for the sake of argument, that the statute doesn't cover speech. I mean, speech triggers strict scrutiny, but there's defenders of the statute that say, what about that savings clause? It says that First Amendment activities are exempt. So I would say, well, one, criticism about a food product. I mean, what are we doing right now? We're talking about, well, Walmart and its pork. I mean, if somebody here decides not to buy pork from Walmart after what Vandana said, then Vandana would be damaging, causing property loss to an animal enterprise, and she's probably, what is her purpose? Is she trying to damage or interfere in animal enterprise? Is she trying to lead more healthful lives, or what? That's why I say it's a problematic element. But I would say even without speaking and just making a choice in a supermarket can also do that.
I just want to add, Dan talked about this, and I touched on the fact that the ag laws, excuse me, would be difficult to prosecute and difficult to defend, but that naturally favors the one who has the most money, and that would be the industry itself. So you have an individual who's trying to defend themselves, but again, they'd have to pay for lawyers, court time, etc.
And yeah, I don't know which is worse, the civil ag gag or the criminal. I mean, discretion as a matter of constitutional law is unacceptable and impermissible, but I don't know, there's just maybe more checks and balances in the criminal justice system than, as civil litigators know, is, almost anybody can walk in and file a lawsuit. So, I don't know which is better, which is the worse, from a justice perspective.
Yes.
Yes, I'm confused if the Supreme Court in Stevens said that the ADA was unconstitutional.
No, I'm just comparing it to the statute I'm comparing it to the statute, it was a Crush video. The law in Stevens punished depictions of animal cruelty. And the court had a problem with the amount of discretion that the law allowed to the other branches. And I'm using recent cases such as Citizens United and Stevens to illustrate that the court has been especially in tune with those types of problems, with clear, broad terms, and the combination between those and undefined terms and savings. These are something, if you read some of the recent First Amendment cases, you're going to find the court speaking on, which is why I took them and I applied them to AIDA.
Okay, so it has, you're hoping eventually it will be found unconstitutional, but that has not taken place.
Well, yeah, some district courts have ruled on it. There's a case called Budenberg and there's a case called Blum. Budenberg rendered a partial ruling as to AIDA, but that ruling is absolutely inconsistent with Supreme Court precedent for a number of reasons. The court, I won't call them errors. I mean, they're inconsistent with Supreme Court law. And Blum dismissed the case for lack of standing. Animal rights activists said they entered a preliminary civil challenge against the Department of Justice against Holder, saying that they would speak, but the statute's chilling them, and the court said that they didn't have standing.
I believe we have time for one more question. Or not. Okay, there's a vegan lunch outside, and come and join us after that for Gary Francione, our luncheon speaker. Our panel.